Thank you so much, Rubina. And thank you also for building in the guilt if people don't laugh at me today. So you've been warned. You should feel bad if you don't find me funny. Before I start, I'd also like to acknowledge that we are on Kaurna land, and I'm privileged to live and work on it, and recognise and pay my respects to elders past, present, and emerging. Just like what I say on social media, today this is not legal advice. Do not rely upon it. It could be terrible. Rather speak to a lawyer who can tell you what the law actually is. And if you need that or some Microsoft Paint work, then those are my details. Actually, let's just correct the bottom one there. Those are my details because the hellscape is a hellscape. If anyone has any questions after this, always happy to have a chat. Find me around. I'll be here all day, I think, I hope. And what I'm going to cover today are a few different topics. So we're going to talk a little bit about what's happened in the past 12 months. There have been a few things. Don't know if you've realized there's been a lot of things happening in recent times, including what those crazy billionaires are doing. We're going to talk about what happens if you decide to take on a court case that you possibly shouldn't have. We'll be putting the AI in the why didn't I speak to a lawyer first? That's classic dad jokes there, people. So I hope you appreciate the vintage dad joke there. And then also talking about misinformation, disinformation, censorship, and things like that. Now, I don't know about anyone else here, but in the past 6 months, I have been to so many presentations where this presenter starts speaking for a while and then stops and says, actually, guys, that wasn't me, that was ChatGPT. I was tempted to do exactly that, but I figured you can't get quite as lame as my jokes are with AI, so this is the real material. If I had used AI instead of the incredible Microsoft Paint artwork that you would have seen, you might have seen this. Or we could have gone with this one. My personal favorite, because I have no idea what on earth it was doing, is this one. I think from memory, the prompt on that one was something along the lines of, put me into the Terminator movie poster. So you've got a little bit of Arnie in there, so, and just I don't know what. But on that very frightening image, let's dive in. So hands up who was here last year. Cool, excellent, excellent. At that last year's presentation, I talked a lot about what had happened in the High Court in the Dylan Voller case. And then promptly 1 week later, the High Court decided to release another decision which kind of changed everything again. So apologies if anyone relied upon the not legal advice last year. Just going to do a very quick recap on a slide that I use pretty much every year because it is important to understand for basically everything else I talk about. And that is about the responsibility of what is said online. So it starts all the way back in 2010, 13 years ago, if you can believe that, where in the case of allergy pathways, the court held that a company who was claiming to cure peanut allergies through a combination of acupressure and homeopathy shouldn't be saying that they could do that where there was no scientific evidence behind it, but then also held that they were responsible for what their customers had said about them at that time online. And Allergy Pathway said, hang on a second, we didn't post that. And the court said, yeah, but you knew about it and you didn't do anything to address it. And so we then had cases involving Smirnoff and whether or not its products makes you more sexually attractive to the opposite gender, which apparently it doesn't, I'm afraid to say. Also having cases where it was pretty much held up that if someone says something about your brand, or if someone says something about you that is false, misleading, breach of advertising standards, etc., you have a responsibility to do something. But at that point in time, the law was you had a responsibility to do something within a reasonable amount of time after you became aware of it. Seems logical. But then things changed. And in the Dylan Voller case, where the gentleman who was pictured on the front page of a lot of newspapers in a horrific situation with a spit hood on tied to a chair at the Dondell Detention Centre, sued a bunch of newspapers and online media outlets saying that they had allowed third parties to make really nasty comments about him online. And he sued them before even telling them he was upset with them. He didn't send any prior notice. He just said, you guys have defamed me. And all of the media companies complained and said, hang on a second, you never said there was a problem. How are we to know that all of this stuff was problematic? And the court found that, too bad, the moment something is published, you are responsible for it if it is on an owned page. So if you are a brand and you have a public Facebook page that is your page and people post commentary on it, you are responsible for what they say the moment it appears online, which is really unworkable because there is no pre-moderation tool available unless you gaffer tape together a content filter using the profanity filter. Now, that went up to the High Court, and last year we found out that that is what the law is. So once it's published, you are responsible. You are responsible if you are a willing participant in what has happened. So by having a public page, by posting content, you are inviting others to respond. And so the court said, well, you are therefore part of this and you should be responsible for what they say. There may, in certain situations, be what's called a defense of innocent dissemination. So that's situations where you can say that I posted a story about the weather and someone responded with some defamatory stuff about a particular person. You say, well, it's not really something that I intended them to, or could be thought to have done. So I was innocent in its dissemination, and as long as I took it down once I became aware of it, I should be okay. But that is not always going to be the case, and it's a defense. So you have to wait until you've been sued, gone through the evidence, and then several $100,000 later, you might have a get-out-of-jail-free card. They also made wonderful comparisons saying things like a Facebook wall is different to a graffiti wall. Don't know why they had to make that commentary, but they did. But then we had a case of Google against Defteros. Now, the facts of this case are that Mr. Defteros has a name that, when Googled, would bring up images of, sorry, I got that the wrong way around. When you Googled Victorian gangsters, his image would come up. That is, by the way, Vince Colosimo, not Mr. Defteros. But in effect, he was complaining that Google was portraying him to be involved in organised crime by virtue of the fact that his image was coming up. So he was accused of involvement, but when you search his name, a couple of things. There was the result that you can see there, that the underworld loses valued friend at court, and it talks to him in a listing under crime and corruption. He complained to Google in 2016, and Google refused to remove them. So let's think about Vola. If we were following the ruling in Vola, we would say that publication occurs the moment something goes up there. Willing participants are liable, so Google invites people to have their websites crawled by their service. They take advertising from companies, and they therefore push out that thing, and they monetize each of their services. So Google should be liable if what the content was in fact defamatory. You'd think on that basis Google should be liable. The first judge, the full Victorian Supreme Court, and 2 High Court justices agreed with that. That is how it should work. But just because the High Court likes keeping things interesting and keeping me in a job, 5 of the justices said that Google wasn't liable. And they made some really great analogies. Like, this case has just some weird things. So they referred to the internet as a large public library. I guess you can kind of see that. Google search results are not the same as an old man sitting on a crate smoking a pipe pointing to an offensive sign. That is actually, there is a case involving that where someone was found to be liable for defamation because he'd been sitting there pointing to something that was defamatory, which is just hilarious. Google is like a librarian who hands you a book with a bookmark in it. Don't mind that one. And it's like an independent for-profit librarian who hangs out at public libraries and helps people find books for a fee. That is possibly the best definition of Google I've ever heard in my life, and I salute the High Court for having made it. So basically what they said was that Google search results are not an invitation for people to post or engage with defamatory content. So they're saying that they're just showing you where things are. They're not endorsing it, they're not inviting you to comment upon it, they're not inviting you to publish stuff, unlike a media publication having a public Facebook page. And they disagreed with the proposition that hyperlinking to defamatory content encouraged people to look at it, which is kind of out of step with a lot of the case law up until that point. Because up until that point, a lot of the defamation cases that we'd been running were saying that if I include a hyperlink to where I know there is defamatory content, I'm realistically directing people to go there and read it, so therefore I'm involved in that publication, even though all I've produced is the hyperlink. Now, whether or not this would be different for a non-search engine, we don't know. But because it is a search engine, they're effectively saying, we didn't tell you that this is what you should click on. You searched for something. Our algorithm served up a hyperlink. Click on it if you like. We're not telling you to do it or not. But they basically said that in most cases, hyperlinks will be highly unlikely to ever be defamatory publications. So none of the judgments really dealt with the question of what happens in the little snippet that goes in under the hyperlink. And I think that there is an open and live question there as to whether or not that could in fact be defamatory content. But what it basically does is we were operating in the system firstly with allergy pathways. We thought we knew what was going on. And that went on for about 8 years. And then a year ago, we got Volo. We thought, okay, cool, it's changed. We think we know where we are. And then a week later, they said, actually, maybe it's not that simple. And so it leaves us in a really challenging situation as people who are working in the online world as to where the line is going to be drawn. Now, I think for most businesses that aren't search engines, you should still probably err on the side of treating Vola as the standard. So when you are working in your business and you are marketing something, if you are going to be posting about anything that is controversial, anything that could reasonably give rise to people posting stuff that is ridiculous and wrong and unlawful, you need to monitor that incredibly carefully. I do think that if you're posting a positive news story about puppy dogs and sunshine and rainbows, that you should be okay. So I wouldn't think that you have to have 24/7 moderation on that particular post. But if you're posting about The Voice, for example, which is a topic where there can be quite emotionally charged responses, I would not want to be allowing anything in relation to that kind of topic to go without someone actively moderating it. And so if you can't have someone there moderating the content, turn comments off until you can. So let's move on now to another fun topic. And those crazy billionaires. We've had some really great things happen with billionaires in the last 12 months, and some terrible things. So I don't know if anyone remembers Twitter this time last year. I mean, this is my recollection of what Twitter was like. It was just utopia. There was nothing wrong on Twitter pre-Elon, right? Right? Yeah, that's right. That's my memory. Now, as of 10 minutes ago, it's not even Twitter anymore, I don't think. It's X, even though the URL is never going to be x.com. I don't know. He's interesting. Credit to the New Yorker for this wonderful, horrific image. But since Mr. Musk has been involved, Twitter has slashed its workforce by 6,500 employees, granted amnesty reinstating almost 10 times that of problematic accounts, and everything's been pretty cool since, right? Everyone's still loving Twitter? Yeah? Yeah? I remember saying last year that I think I'm the only person who still enjoys Twitter. Now I'm definitely not. I don't think there's anyone who enjoys Twitter, not even me. And looking at the stats and looking at the reactions that people have had, it is reasonably clear that Twitter is not a safe space right now. So if you just look at some of just those things that come out, it's the most hateful platform. That's a big call. Doubling of the slurs against African American people, 61% rise in anti-Semitism in the 2 weeks after Musk took over. So, firstly, I didn't realize that was animated, so you're welcome. So now, why do we think that I might be talking about the train wreck of a dumpster fire that is Twitter in an illegal presentation? Answers A, Schadenfreude. I do enjoy seeing things that rich people have being destroyed. Twitter's revenues fallen by more than half. That's just like I just like saying. It's amusing after he paid $44 million that its revenue is halved. There was a law that passed in Australia in 2021, and D, all of the above. Can I have any hands up for A, B, C, D? Wow, that was a really unnecessary animation on that one. Yes, that is right, all of the above. Because in 2021, Australia passed some world-leading legislation, the Online Safety Act. And under the Online Safety Act, it was necessary for social media platforms and anyone who controls an owned community to grant a basic online safety expectation. And that requires people to ensure that, platforms to ensure that there are reasonable steps taken to ensure the safety of their users. There need to be appropriate mechanisms that report and allow complaints about harmful content, rapid responses to the E-Safety Commissioner and the provision of information to the E-Safety Commissioner. Cyber abuse is now unlawful in Australia, and the penalties can be significant. Now, in the context of that legislation, we then have a social media platform with a significant user base in Australia, maybe not as significant as it used to be, but still a reasonable sized base, and it's now providing what I would argue is the least safe space on the internet. We used to be at 4chan, I think now Twitter's giving it for a run for its money. Now, the E-Safety Commissioner is still reasonably new in her role, and we still haven't seen any major cases work their way through the courts to determine how strong the enforcement powers are going to be, particularly against offshore entities. Because as someone who has frequently had to go toe-to-toe with social networks, I can tell you, just getting them to show up in court is challenging. Because you'll send something to their Australian entity and they'll say, no, 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 that's a marketing company unrelated to the running of the platform. So you say, okay, cool, I'll send it to their Irish company, because that's the one that says that it's in the terms and conditions. No, no, they're acting as agent for our US company. So you send it to the US company and say, no, no, we've changed this week. It's now the Irish one again. And so that's just life as normal dealing with social media platforms. But now we have the E-Safety Commissioner, and the one interesting thing is that if you don't respond to her, technically you are up for a penalty of $700,000 a day if you don't respond in time. Now, a notice was served on Twitter on the 22nd of June. A response was required to the E-Safety Commissioner on the 20th of July. As of last night when I checked this, there hadn't been any updates as to whether or not Twitter had responded. She'd basically said, so, things look a little bit interesting over there. What's going on? Basically asking for information as to how many complaints are they getting? How are they dealing with those complaints? What steps are they putting in place to deal with misinformation? What steps are they putting in place to manage the various issues that are arising? And it'll be very interesting to see what they come back with. I must admit, how they are going to manage to meet the requirements of a basic online safety expectation is beyond me, because when they've fired pretty much their entire moderation team and it's just is what it is, I think they're going to be in a lot of trouble. The other thing that's interesting is that now that Twitter's decided to rebrand itself as X, Elon Musk might be getting a very quick lesson in trademark law, because the logo there on the left is owned by Meta. The logo on the right is owned by Microsoft. They relate to social media platforms, provision of forums, online content, and as a result of that, it is likely that there will be a trademark infringement case against Twitter pretty soon. So everyone going to Threads now? This is my challenge for you. Get me into triple digits on Threads, at Paul Gordon AUS. Little plug there. I'm trying to make Threads a thing. I'm hoping it's a thing. You know, I tried LO when it came out and I'm still burnt because no one else joined me there. The e-safety commissioner has also been very busy. There have been over 800 cyberbullying complaints in the last 12 months. Surprisingly, TikTok was the worst performer in terms of complaints. And there have also been a number of high-profile referrals, sorry. This is what happens when you get me on first in the morning. I'm not good at words. So the AFL, there was a number of rather nasty things said on social media about a number of different players, quite racist and inappropriate commentary, and that's been referred to the e-safety commissioner. Because you might remember that an individual cannot themselves take someone to court for a breach of the Online Safety Act. It must be done by the e-safety commissioner. And so if I can't get the e-safety commissioner's attention, I'm not going to have a remedy. So it'll be interesting to see whether or not it's only the high-profile cases that get picked up by the commissioner, whether or not she has enough staff to deal with what is likely to be an increasing volume of complaints, and whether anyone actually pays attention before they get fined. So still watch this space on all of that. Now I'm going to take a bit of a break from levity. I was going to throw some jokes in, but I don't think it's appropriate. I think it is important to talk about this topic in a more sober way, and that's to do with the Ben Roberts-Smith defamation case. So if you've been following along with the case, Ben Roberts-Smith, highly decorated soldier, was the subject of a series of articles that related to his behaviour. And he sued Channel 9, both for their print and their television content and online content, in relation to a number of those allegations. Now, this was a situation where no one asked him to take that case on. He decided that it was important to sue. And unfortunately for Mr. Roberts-Smith, he came out very poorly. So the judge found that there was, on a more likely than not decision-making balance, evidence that supported claims that he committed some horrific war crimes. The reason why I raise this is that it is also an important lesson in one of the defences to defamation that I think it's wise for everyone to be across, and that is the concept of contextual truth. So together with the war crimes allegations, there was also a series of allegations that were made against him for domestic violence offences. And whilst the judge didn't say that those didn't happen, he said he didn't have sufficient evidence on what's called Briginshaw certainty, which is more likely than not that it happened, about those offences. However, because the war crimes allegations were so abhorrent, the court basically said that no one is going to think worse of him because of an allegation of domestic violence offences, because his reputation has been so badly tarnished by the other things that were true. And so you need to remember that if someone says something which harms a person's reputation, but also has said that is untrue, but there's also something that is true that's even worse, you're not going to be able to sue them successfully for defamation for the thing that wasn't true, because once your reputation's trashed, you can't make it much worse. So just a little lesson in contextual truth. And now we'll move on to more exciting topics, like NFTs. No, I was not going to talk about NFTs. I just think it's amusing that we all thought they were going to be a thing, and now they really aren't. Talking about AI. So this has been obviously the hot topic of conversation in recent times, and we've seen the very impressive technologies coming out from OpenAI, to a lesser extent Google. I heard yesterday that Meta have now released Llama 2, which is a great name for AI. Why not? But the main thing that we're talking about here is generative AI, which I always like to think of as Clippy Mark II. Fun fact, not actually called Clippy. That has just been like a nickname that has arisen over the years. But in effect, that's what we were trying to achieve here. We're trying to achieve the talking paperclip, who you'd ask a question and it would find you the answer. And it's a great tool. We were talking about it yesterday in terms of all the possibilities that it offers, but it also has some significant legal implications. And I'm just going to talk very briefly about how one trains AI, because that's important to understand to go through the legal issues. By the way, this was the generative AI output for Clippy working out and training, and Ask Jeeves at the gym, which I just love. I want to see some kind of Netflix series about this guy and the adventures he gets up to as a butler who works out. So the way in which training of AI works is that basically you say to the AI, here's a bunch of stuff, and here are a couple of reasons why these things are connected in different ways, and then you go, AI, and figure out all of the connection points. And it makes multiple connection points between the different bits of information and comes up with a machine-learned knowledge base. Now, if we look at, for example, ChatGPT, because that's the one that everyone talks about, that has been trained on the internet up until September 2021, or at least GPT 3.5 was. I think GPT 4 is now more current. And that's great, but who gave them permission to trawl through the internet and utilize people's content for that purpose? And there is a significant question to be asked whether or not training a GPT-based large language model on other people's content infringes their copyright. Now, to decide whether or not that's happened, we have to look at a series of factors. So firstly, is what has been looked at substantial? Is it the whole of something or just a tiny piece? Is the AI actually reproducing the content, or is it just looking at it? If I walk past a photograph on the wall and look at it, that's not a copyright infringement. If I take out my phone and snap a picture, that is. So is it actually reproducing it? And does it fall within a fair dealing exception? And this is why we might actually see a lot more copyright litigation against AI companies in Australia as opposed to the US. Because in Australia, we have a much more restricted defense to copyright infringement called fair dealing. So in the US, it's called fair use. And it's pretty broad. If you can show that what you're doing is fair and you're using it for an appropriate purpose, you can do what you want effectively. And so research and development, you can probably get through an exception there. But in Australia, you have to be much more narrow. You have to be showing, in reality, the only one I can think of that would apply is that it's for the purpose of research or study. But it's not research or study in general. You can't do it for commercial purposes. It must be for your own personal research and study before you can get out of jail with this one. And I'm not convinced, firstly, that training of an AI necessarily falls within that exception if you're doing it for commercial purpose. If you're a university doing something for not-for-profit sort of aims, then maybe. But I also don't know if you could say that it's fair, because you're taking the entirety of someone's work. If I've produced an image or written a book, and it's just reading through the whole thing for the purposes of producing generative outputs, I think that's potentially not really fair at all. And it might be, as I say, different as to whether or not it is being trained before launch, when you're not actually commercializing it, and after launch. I think there is an argument to say that, well, when OpenAI was preparing it within their own R&D environment for their own internal testing purposes, that was fine. But if they now start to go beyond that, now that it's a commercial product, we're no longer within the fair dealing exception. And we're going to find out pretty soon what the output is in terms of the court cases, because a number of people are suing. So Sarah Silverman, comedian, author, is suing ChatGPT, OpenAI I should say, for effectively reading her book and then allowing people to say, write me something in the style of Sarah Silverman. We're seeing that there are artists who are suing, so Getty Images is suing Stability AI, because not only are we seeing images reproduced with elements of other people's artwork, we're even seeing the watermarks being reproduced. So it's very clear what the AI has been trained on, because it is demonstrating that publicly. So I think that there is a real issue with the training of AI and whether or not it does or does not infringe copyright. There's a real question as to what the remedy is. And I'll talk a bit later about what's happening in the creative arts industries, for example, with the current SAG-AFTRA strikes, the Writers Guild of America strikes, and what that's all going to mean in an AI context. The other thing that's going to be interesting is who owns the output. And I should say, as I'm walking around the stage, because I can't stand still, I've apologized to everyone who's trying to film or photograph me at the moment, because I'm just making it difficult for you. In Australia, the courts have held for a long period of time that in order to own copyright in something, there needs to have been substantial independent human intellectual effort, which means that even Rachel Black's song Friday is probably covered by copyright. And the courts have found in other contexts that AI-generated output, well, not necessarily AI, but machine-generated outputs are not something that can be protected by copyright. So in the ICE TV case, where ICE TV was using an algorithm to produce the TV guide for set-top boxes, it was held that that was not copyright material. And that the outputs from the various TV channels was not copyright material, and that's because it was all machine-programmed and machine outputs. So if we look at applying the same logic to AI, is very arguable. In fact, I think it's probably the correct answer here in Australia to say that whatever comes out of ChatGPT is not owned by anyone. It's not owned by the person who created the AI. It's not owned by the person who produced the prompt. It's just public domain, effectively, upon its creation. Now, that isn't necessarily going to be the case everywhere in the world. Different countries have different approaches, and I'll go through that in a little bit more detail later. But in Australia, what we're really going to be looking at is whether or not there was substantial input by human intellectual effort into what was put out, whether it involved a creative spark, and also whether it was created by a crested macaw. For those who don't remember, that image there was actually taken by the macaw and is not owned by anyone's copyright. The person whose camera it was tried to claim ownership of that image, but actually it's owned by the monkey. So if we compare it to around the world, so in Australia we've got the position not copyright, probably. Haven't had a direct case on it, but most likely position is going to be generative AI outputs are not owned by anyone. UK, same reasoning, not copyright. US, it can be. And so we are moving again to a situation where previously copyright laws were pretty universal. You had some differences around fair use, fair dealing, but it was pretty much the same. Now we're going to see situations where there might be greater protection in certain countries who are trying to build an industry around AI. Because if the laws in Australia say you don't own the outputs, but the laws in the US say that you do, there's more of an incentive for AI companies to market their products there because they can provide people with greater certainty and ownership of what the outputs are. Another issue, though, with AI is hallucination. And that it refers to the situation in which you ask the AI a question, it provides you with an answer, and the answer is just made up stuff, but it is said with authority. And so people rely upon it, and it gets them into trouble. So in the US, there was a lawyer who was trying to put together written submissions for a case. And so he went into ChatGPT and said, find me case authority for this proposition. And ChatGPT said, cool. He gave him a whole bunch of case names, citations, years, where it happened, etc., case summaries. Brilliant, he thought. Put it into his submissions, filed it with the court. The other side looked up those cases and found that they did not exist. They were all completely made up. And so the lawyer went back to ChatGPT and said, these cases are real, right? And ChatGPT said, of course they are. So he went back to the court and said, no, they're real cases. He still didn't, for some reason, actually look them up. And then finally the penny dropped when the judge said, no, they don't. And so he had to file affidavit saying, my bad. Apparently ChatGPT isn't a lawyer yet. And it's gone around, the legal community around the world are all pissing themselves laughing at this, despite the fact that we all would have done it had we not been shown that this was a potential factor. I'm almost done. So it is an interesting thing to note that you need to be very careful about what is actually coming out of these generative AI outputs to make sure that, firstly, you're allowed to use it, and secondly, that it's accurate. There are also significant privacy implications. So OpenAI was banned from operating within Italy at one stage because of the concern that the process of training the AI and the process of receiving prompts breached people's privacy rights under the General Data Protection Regulation, the GDPR. And OpenAI have made some tweaks to how they do things, and now they're allowed to operate there. But the question still remains as to what happens when your information gets into an AI, and can AI actually forget? I don't know the technical answer to that, if you can remove information from a Learn module, but maybe someone in the room knows the answer to that. But is it actually handling personal information? And I'm just going to, I've realized I put my slides in the wrong order, so I'm going to skip a couple of slides. But it really brings into focus the question of who owns your image. And in Australia, the position generally is that not you. If someone takes a photograph of you, if someone takes a video of you in a public place or in a place where they are allowed to take photography, or if they can see you from a public place, there's not much you can do about it unless they are indicating that you have provided some kind of support. I mean, I'm referencing Beyond 2000 because I still remember, obviously pre-2000, watching an episode where they're saying, in the next decade, we're going to have movies where you won't have any of the actors or actresses actually having done anything, and it'll all be computer-generated modules. And we all thought, ha, 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 you silly Beyond 2000 people, of course that's not going to happen. But now, we're in that place. We have reached the point where the technology is sufficiently powerful to be able to capture a person and use their image and likeness indefinitely. And I mean, we're seeing some of the things like this happening here in Adelaide, in fact. So the Bond brothers are currently threatening legal action against Port Adelaide and the Crows for using their image, this picture, which was not taken by them, obviously, because they are in the image, and that is not owned by them because they did not pay the person to take the photograph. But they're arguing that because it indicates some kind of connection to them, that image is used on the showdown medal, that they should be receiving some kind of compensation. Novel area to argue, because in Australia, to date, you do not have rights to your own image. And part of what's happening with the SAG-AFTRA protests is concern over what's going to happen. And there's a really cool video, if you look it up. In fact, if you go to Jamie Lee Curtis's Twitter account, she asked for people to send her a link to it. It's actually a TikTok video of a guy sitting on some steps surrounded by AI images of himself, and complaining that very soon we're going to see situations in which all of the extras in a movie may well be AI generated. You might get paid for one day's work to stand and turn and move in a particular way so that it can capture what you look like, but then we're going to see those people not having a job anymore. So it's not necessarily going to be the big name stars. I don't think we're going to necessarily have Tom Cruise AI as opposed to Tom Cruise, although he is getting on and the Mission Impossible movies do need to continue, so who knows, maybe. But it is kind of frightening that we're in the stage where that's going to happen. And what we might even find is that this could happen to you. You could be walking down the street and someone, Rundle Moore's taking photos of you. You can't stop them. It's their right to do that in a public place. And then they might, if it's not commercial, if they might just use it for some purpose, they can use your image. And are we okay with that as a society? The last thing I'll say before we get on to questions, I just have a couple of other slides of who's liable if something goes wrong. So let's talk about that case with the lawyer who used the wrong citations. Can he sue OpenAI for the hallucinations? Probably not. ChatGPT is not purporting to be legal advice. But are those organizations who are putting these out there going to be liable for the promises they make about what their product can achieve? And if you rely upon it, at what point can you say, well, it wasn't fit for purpose? You were marketing this to me as something that could generate content for me that I could use in my business. You've actually breached a whole bunch of people's intellectual property. You've told me information that is wrong. And for some reason now I've applied the wrong product and suffered an injury. Is it going to be the tech billionaires? Well, probably not. So on that cheery note, I'll skip through slides again to questions.
Always good fun. I can assure you this is the real Paul Gordon. It's not some AI-generated hologram. Thank you all for all your questions on Slido. There are so many. We are going to take a few, and I also want to say thank Toby as well for letting us run over a couple of minutes. First one from Vivian. Recent data breaches, like Optus, raise questions for marketers. Is stronger data security and verifying digital identity our responsibility to protect a brand image?
Okay, so in terms of data breaches and where the responsibility lies, I think that the first point is that under the Australian Privacy Principle number 11, remember to number for once, you have an obligation to ensure that there is appropriate security for the sensitivity of information that you hold. Now, that is not a marketer's job, that is your IT team's job, realistically. But if they have dropped the ball, then it is the organisation that is going to be held liable. We deal with data breaches all the time, though, and in the vast majority of them, you'll find that unless you're a high-profile organisation who have been doing stupid things for many years, there's not a huge amount of fallout because society is starting to understand that these things happen and that no matter what kind of security things you put in place, someone can always get around them. So I would be saying that you should be talking to your organisation and saying, can you give me an update as to what we do from a cybersecurity perspective so that if there is a breach, I know what to say on our comms.
Yes.
I know I can say that, look, we use this level of sophistication. We do penetration testing. We have outsourced to one of the big global players our cybersecurity. Despite that, unfortunately, this has occurred. However, these are the steps that we're now taking to make sure it doesn't recur. But get that information up front because the worst time to be asking your IT people what is our security is when it's been breached. So definitely a good question for everyone to ask. And make friends with your IT professionals.
Here's an oldie but a goodie from Emma. How should social media managers navigate memes and copyright?
Okay, so the general position is that memes are 9 times out of 10 copyright infringing. Unless you are using a public domain image or something which has been licensed to, for example, a GIF gallery, then your use of it is potentially breaching copyright, particularly in Australia. In the US, you might have been able to argue fair use. In Australia, the best you're going to be able to come up with is probably parody or satire, but if you're not making a parody or satire of the thing that you are using, then that is questionable. So my general tip is use memes from the 1800s when they're public domain. Great way to engage with your audiences. As you can see, I'm very clearly a marketer.
What about defamatory comments on a business's Google profile, like fake and false reviews? It's near impossible to get fake reviews removed. This one comes from Anna Spencer.
Look, it is incredibly challenging to get rid of bad reviews. If you look at the Woolman's page, we've got people who are upset with our vaccination policies. Never used us, never walked through the doors, but because we had a vaccination policy, we've got 1-star reviews from a bunch of people, and Google don't care. To be honest, it's much easier to get rid of a review that has content in it. The hardest reviews to get rid of are the 1-star, no commentary at all, because it's difficult to demonstrate that that is in fact defamatory content. You then add to that fact that the defamation laws in Australia say that you can't sue for defamation unless you have fewer than 10 employees or are a not-for-profit, which then takes people out of that ability as well. There are ways to do it. It is time-consuming. It takes months and months and months and lots of effort, and it doesn't always work. Be very wary of companies who claim that they can get rid of bad reviews. I work in this industry and I do not understand how they can claim to be able to do that.
Yeah.
They can harvest fake ones, fake positives to bury it, but it's really challenging otherwise.
Kat and Emma had a very similar question. So we talked before about ChatGPT and Bard, and I guess that would cover Midjourney and any of those kind of image generating ones as well. So what happens if you use the AI to basically create your first draft or second or third draft, but then you substantially edit the content?
Yep. So
what kind of impact does that have then on whether you've breached or whether you've actually changed it enough? And I actually have a follow-up on this one, but yeah, go on.
So I don't think you have to worry about breaching because there is no copyright in the output. But at the moment, if Sarah Silverman and Getty Images get their way, then there might be, but that's more on the AI company as opposed to you as the end user. If you have then used Creative Spark, substantial efforts to change it, then you would have copyright in the modified version, absolutely. So it is actually a really great tool if you need to own what you're producing. As long as you are substantially modifying it, I have no issue with you then claiming copyright.
Okay, so then I'd also argue then, so what's the difference between me telling ChatGPT to do my research for me, apart from it getting it wrong, or Bard doing my research for me then? Because I guess for me as a marketer, considering it, like it'd be more like, well, that's just saved me like 2 hours of having to go scour the internet. I mean, you look at things like SEO, like there's some fairly standard things that you should include in a blog post, for example, about how to get good SEO results or how to improve your SEO or on-page SEO. There's only so many answers to that question.
Yeah, and so I don't,
So,
I
you
certainly,
know, like,
yeah.
like,
I don't want to be seen to be saying you shouldn't be using AI. You absolutely should be using AI. It's just about understanding where the legal limitations are. Firstly, verify everything independently that is in it. Secondly, if it's using a watermark from someone else with an image that you've created, maybe don't use that one. And don't think that your competitors won't have access to the identical thing. Because that's the other thing. If you get a logo created or something like that, there's nothing that stops Stability AI generating exactly the same thing for someone else.
Final question from Makisha. There's more here, but Paul's around all day, so you can ask him anytime today. Makisha asks, do you have any recommendations for digital marketers to follow or subscribe to keep up to date on the latest news in this space? Does the Warman's newsletter help you out with that?
So we do post on the Warman's website updates when interesting things happen and we have time to talk about them. Other than that, I would recommend the Copyright Society's website, copyright.org.au, which have incredibly good fact sheets, and they are updated regularly. So if you want to know anything in the world of copyright, they are free and they are excellent. I don't think that they necessarily push them, so it is something that you have to go on and check, but definitely worthwhile looking at that. And the other one is the Arts Law websites. They're for creative industries, but they do have some really useful tips that are put out there on a regular basis.
Very good. Would you thank Mr. Paul Gordon?